In a shock twist inside the Gauteng High Court, the state, led by Advocate Baloyi, has suffered one of its most devastating blows yet. The court has ruled that the prosecution cannot use the alleged confession of accused number 2, Bongani Ntanzi, to cross-examine accused number 1, Muzi Sibiya. This is more than just a ruling. It is a legal earthquake. Baloyi argued fiercely that Ntanzi's statement was fair game, that it could be used to corner Sibiya, to expose contradictions, to revive a narrative the state has clung to since day one. But Judge Ratha had other plans. With precise legal reasoning, he blocked the state's attempt, declaring that the confession is out of bounds for this line of attack. And with that single ruling, Baloyi's strategy crumbled on the spot. The courtroom fell silent. The defense table quietly celebrated, and the state was left scrambling. For the defense, this is an enormous victory. Every time the state tries to revive these controversial confessions, the defense shuts them down. And today was no different. This ruling removes one of the prosecution's sharpest tools. Without Ntanzi's statement, Baloyi faces an uphill battle, forced to rely on weaker evidence, questionable witnesses, and a theory that now looks even more fragile. It also boosts the credibility and confidence of the accused. Each procedural win adds pressure on the state and creates doubt in the hearts of observers following this marathon trial. Is the prosecution running out of ammunition? Is their case collapsing in real time? Because today the tables turned, and it was the defense walking away with momentum. One thing is clear. If Baloyi hoped to corner Sibiya using Ntanzi's confession, the legal gate just slammed shut in his face. And the defense? They smell blood. Stay tuned.
All right. Friday, I said I would make a ruling today. And I want to emphasize, it is a ruling. It is not a judgment. It is a ruling on a point of law. But it also happens to be a constitutional point. When Mr. Baloyi intended to cross-examine Mr. Sibiya using the statement or the confession of Mr. what's his name, accused number 2? Ntanzi. I said to him, is that the correct procedure? Is it admissible, the evidence you're going to adduce? Then Mr. Baloyi addressed me, and thereafter the whole defense team addressed me. Yeah. So I researched a bit, and I found the case of Mhlongo. I think it is applicable here because in the Constitutional Court, in that appeal, the defense raised 2 constitutional issues that the circumstances surrounding the cross-examination of that of those 2 accused was not fair because it transgressed or contravened Section 9 of the Constitution, which guarantees that an accused should be accorded, or all accused in a trial, even the witnesses of the state, should be accorded fairness. They mustn't be treated unequally. And further, that Section 35F of the Constitution was being transgressed because it deprives accused number 2 the unfettered right to give evidence. We must remember, he hasn't given evidence. And he also has the right to challenge evidence, even the evidence, if he wants to, of accused number 1. So that right remains unfettered. And what has happened in this case, Mr. Baloyi has already cross-examined accused number 1 regarding the so-called confession or extracurricular statement he made. And this court, you'll recall, all I did was to make a ruling that the statement or made by Mr. Sibiya. Is it Sibiya?
Sibiya.
Sorry, I'm sorry. It's not the status of that statement has not been defined, definitively defined by this court as a confession or as an extracurricular statement. Mr. Baloyi calls it an executive statement. Because what has happened is, normally a confession, State versus Bartman, I think 1929, defines it as an unequivocal admission of guilt. But if you look at the statements made by Mr. Sibiya and Mr. Ntanzi, they are not unequivocal admissions of guilt. An unequivocal admission of guilt is where a person makes a statement and admits all the elements of the offense. Like saying, I killed Ratha and burned his body. But in this matter, which we are having, we have not yet, as I say, made a definitive statement to the status of the statements, what they are as from the court's perspective. This very issue was transgressed and debated in the case of Oswald John Mhlongo and the state, and Alfred Disco Nkosi and the state. I'll just read the law as expounded by the Constitutional Court. Equality before the law, that is Section 9 of the Constitution. It was contended by the applicants that the distinction drawn by Ndlovu between admissions and confessions effectively leads to indirect differential treatment between groups of accused persons. Those implicated by an admission on the one hand and a confession on the other. A confession is inadmissible against another person, while according to Ndlovu, an admission may be admissible. We all know that Ndlovu was set aside. It violates Section 9(1) of the Constitution, which provides that everyone is equal before the law and entitled to equal protection and benefit of the law. The distinction between the confession and admissions is determined solely by the extent to which the statement implicates its maker. This distinction becomes relevant in determining the safeguards that are put in place to ensure the voluntariness of the confession or admission. If a confession can be used with little more to secure the conviction of its maker, as opposed to an admission which would still require the state to prove various elements of the crime, then there may be logic in applying more stringent requirements on its admission against that accused. The distinction apparent in the difference between Section 217 and 219A of the current CPA, however, the distinction has nothing to do with a third party. Accordingly, there is no rational reason why, when used against another person, there should be a difference in the admissibility of the two types of statement. The Supreme Court of Appeal in the case of the Tago said the following: from the perspective of one accused who may be implicated in the statement of another, one strains to discern a sound jurisprudential basis for the distinction. While the court in Mulimi declined to pronounce on the issue, it did state that the argument may be sound. The differentiation must be evaluated in terms of Section 9(1) of the Constitution. This court has held that a distinction made in the law will contravene Section 9 if it is irrational. The purpose of this is to ensure that the state functions in a rational manner in order to enhance the coherence and integrity of the law. This is essential to the rule of law, the fundamental premise of the constitutional state. It must be ascertained whether the differentiation complained of is rationally connected to the achievement of a legitimate government purpose as opposed to being arbitrary or capricious. To this end, a legitimate purpose must be identified. It is difficult to conceive of any rational reason why an admission ought to be admissible against a co-accused, but not a confession. The state offered no reasons in this differentiation. The rationale for precluding the admissibility of a confession, the inherent dangers in using statements by co-accused, which is expressly guaranteed in Section 219 of the current CPA, applies equally to admissions. The TACO expressed concern that the mere characterization of a statement as a confession or admission could determine its admissibility. It has not been done here by this court. That concern became manifest in this matter. The High Court initially characterized the extracurrial statement by Mr. Macheke and Mr. Kanye as confessions, only to later recharacterize them as admissions. It was contended by the applicants that this was an attempt to force open the door to the admission of these statements as evidence against them, and that this could undermine the integrity of the courts. Even though admissions and confessions are distinctly defined, it is possible for courts to get it wrong with possible prejudicial consequences for an accused. The differentiation between the accused implicated by confession versus admissions cannot be lawfully sustained. It is not designed to achieve any legitimate purpose. It is an irrational distinction which violates Section 9(1). It cannot be saved by the limitation clause contained in Section 36 of the Constitution, because this limitation of the right to equality before the law is not reasonable, justifiable in an open and democratic society based on human dignity, equality, and freedom. Nor did the state seek to justify this limitation. Right, so that is the reason this court said maybe it would be infringing on the rights of accused number 2 to use number 2's statement or confession to cross-examine Mr. Sibiya. All right, the common law exception. At common law, there is an exception to the exclusion of extracurrial statements of co-accused if the statement constitutes an executive statement by an accused. This court has not made a finding that the statements of any of the accused, 1 or 2, are executive statements. Persons or people must remember that this case is still continuing. That election will be done by this court at the end of the case, after all the parties have addressed the law, the facts. But at this moment, this court is still continuing. Only one accused person has given evidence, although he has not yet completed his evidence. So that's the reason I say I'm not interpreting the law. I'm just saying this court has not as yet said any of the statements here of either 1 or 2 constitute an executive statement that is by an accused. It may be admissible against a co-accused if it was made in furtherance of a common purpose or conspiracy. This court has also not made a finding as to whether all these accused before court acted in pursuance of a conspiracy or a common purpose. There must be other evidence aliunde to establish the existence of a common purpose before the statement can be taken into account. This court has not pronounced on the evidence aliunde. This court may have pronounced on the application lodged by Mr. By accused number 4's counsel when he was bringing an application, that is Mr. Mapisa, when he was bringing an application on behalf of Mr. Mapisa, all the court pronounced upon was that the evidence of Zungu was not so hopeless that it can be thrown away. And that is the only attack Mr. Ngumalo made in that application for 170. And I opined that there's other derivative and constructive evidence which was led in this court. For instance, I said, there was evidence pertaining to cell phones, etc., etc. So this court never pronounced itself on the other evidence which Mr. Ngumalo ignored. And I said, the case against the accused is not only predicated only and solely on the evidence of Zungu. Consequently, that's why I say there's merit by the defense to say that at this juncture, there is constitutional invalidity regarding Mr. Baloyi's attempt to take the statement of accused number 2, who has not yet cross-examined Mr. Baloyi, Mr. Sibiya. And that is frowned upon by section 9.1. And consequently also it infringes section 35 of the Constitution regarding the freedom of a litigant or an accused person to give evidence and attack the evidence of a co-accused if he so desires. Consequently then, the ruling I made against Mr. Baloyi stands that he cannot use the evidence, the statement of accused number 2 to cross-examine accused number 1 because of the exigencies which I have mentioned, that no pronouncements have been made regarding the status of the statements or confessions or pointing outs. The case is still ongoing.
With the prosecution blocked from using Ntanzi's confession, is the state losing grip on its own case? Did this ruling expose deeper cracks? Or will the state return with a stronger strategy? Is this the turning point the defense has been waiting for? Baloyi is still busy with Sibiya statements, trying to find money paid in by Kelly Kumalo for the hit. This is weird, isn't it? Let me know. Do you think this judgment weakens the prosecution beyond repair? Are the accused inching closer to freedom? Or is another twist coming? Drop your thoughts below. I'm reading them. I'm Skybridge. Thanks very much for watching. Don't forget to like, subscribe, and share for more updates as this explosive trial unfolds. Until next time, goodbye.